Resuming debate, the Honourable Parliamentary Secretary to the Minister of Justice and Attorney General.
Thank you, Madam Speaker. And at the outset, let me acknowledge that I'm speaking to you from the traditional lands of the Algonquin people, and I want to acknowledge the lands from which our colleagues are joining us today. It's a solemn honor and a pleasure for me to rise in this debate and to speak on the proposed constitutional amendment in relation to Saskatchewan. It is not every day that a motion for a resolution to amend the Constitution of Canada comes before this House, and I want to thank the member for Regina Louvain for bringing this forward. Indeed, a resolution authorizing the proposed amendment has already been adopted by the Legislative Assembly of Saskatchewan. The amendment, if also authorized by resolutions of both Houses of Parliament, will repeal a provision of the Saskatchewan Act that was enacted by Parliament in 1905, but is now an entrenched part of the Constitution of Canada. Honourable members are aware that 40 years ago, the Constitution was patriated by the enactment of the Canada Act 1982. No longer would the United Kingdom Parliament legislate for Canada, including making amendments to its Constitution. The Canada Act 1982 completed Canada's journey from a colony to autonomous dominion to full independent state, while preserving our institutions and traditions of parliamentary democracy and the rule of law. Our government is proud to support the province and the people of Saskatchewan in supporting this important constitutional amendment to ensure that the tax system in Saskatchewan is fair and ensure that all corporations pay their fair share of taxes. The Constitution Act 1982, which is scheduled to the Canada Act of 1982, constitutionally entrenches not only the Canadian Charter of Rights and Freedoms, recognizes the rights of Indigenous peoples of Canada, and sets out the commitments of governments to promoting equal opportunities for all Canadians. It also establishes the procedures for constitutional amendment. There are 5 amending procedures. 2 of them we have often heard about: the General Rule, or the 750 procedure, and the unanimous consent procedure. The general procedure requires the approval of at least 7 of the 10 provinces' legislative assemblies representing 50% of the provincial population and the 2 federal houses. Only 1 constitutional amendment has been made under the general procedure, and that was in 1983 to strengthen the rights of Indigenous peoples under Section 35 of the Constitution Act of 1982. The unanimous consent procedure, which applies to a limited number of subjects, requires the approval of both the Senate and this House, as well as 10 provincial assemblies. Both the Meech Lake and Charlottetown Accords, to succeed, would have had to meet this stringent standard. As well as the 2 multilateral procedures, there are 2 unilateral procedures of limited scope. The Parliament of Canada can amend the Constitution in relation to the executive government, or the Senate and House of Commons, subject to the protection of the fundamental characteristics of these institutions by the multilateral amending procedures. That is how Parliament amended in 1985 and 2011 Section 51 of the Constitution Act 1867 concerning representation in the House, and each provincial legislature may amend the Constitution of the province as long as it does not infringe fundamental provisions such as Section 133 of the Constitution Act 1867 and Section 23 of the Manitoba Act 1870, which protect language rights. And now we come to the bilateral constitutional amendment procedure. It is this procedure that the Legislative Assembly has invoked, and it is set out in Section 43 of the Constitution Act 1982. An amendment to the Constitution of Canada in relation to a provision that applies to 1 or more, but not all provinces, may be made by a proclamation issued by the Governor-General, where authorized by resolution of the Senate and this House, and of the Legislative Assembly of each province to which the amendment applies. That's the case here, Madam Speaker. The provision that would be amended, Section 24 of the Saskatchewan Act, only applies to Saskatchewan and the Legislative Assembly of that province to which the amendment applies, the Legislative Assembly of Saskatchewan has authorized this amendment. It is now for the two federal houses to determine whether to adopt the resolutions authorizing the same amendment, the repeal of Section 24. The bilateral procedure can be viewed as a middle ground between the multilateral procedures requiring unanimous consent of the federal and provincial houses at one end, the unilateral procedures allowing for an amendment by an ordinary act of the legislature on the other. The bilateral procedure is found in Part 5 of the Constitution Act 1982, which the Supreme Court of Canada has said, and I quote, provides the blueprint for how to amend the Constitution of Canada. The court called Section 43, the bilateral formula, the special arrangements procedure, which applies in relation to provisions of the Constitution that apply to some but not all provinces. The court noted that it would be an overshoot to make adoption of the amendment dependent on the consent of provinces to which the provisions does not apply. Section 43 of the Constitution Act 1982 also serves to ensure that a special provision cannot be amended without the consent of the province to which the amendment applies. The bilateral constitutional amendment procedure has produced no fewer than 7 constitutional amendments. 4 of them concern Newfoundland and Labrador, 1 changing the name of the province to include Labrador in 2001, and 3 changing the denominational schools provisions of the Terms of Union in 1987, 1997, and 1998. 1 was made at the request of Quebec and also concerned denominational schools provisions to remove their application as to favor the organization of school boards along linguistic lines, and that was done in 1997, Madam Speaker. 1 was made at the request of New Brunswick in 1993 and added Section 16.1 of the Canadian Charter of Rights and Freedoms, and thus recognized the Constitution, the equality of the English and French linguistic communities in the province. And 1 was made at the behest of Prince Edward Island in 1993 to remove the requirement in the Terms of Union for Canada to maintain a ferry service, thereby facilitating the substitution, the construction of the Confederation Bridge to the mainland. These amendments all have the same things in common, Madam Speaker. Each amendment provisions of the Constitution of Canada that applied to less than all provinces. Each amendment applied only to 1 province. Each amendment was initiated by the Provincial Assembly of the province in question and considered by the federal houses, and each amendment modernized certain aspects of the Constitution and demonstrated federal-provincial cooperation. La modification proposée.
The amendment proposed by the Legislative Assembly of Saskatchewan is similar to the 7 others already passed under the bilateral procedure since 1982. It seeks to amend the provision of the Constitution that does not apply to all provinces. The amendment itself will apply to only 1 province. The initiative for the amendment was taken by the Legislative Assembly of the province and is now before us. And the amendment would modernize certain aspects of the Constitution. In this case, removing a limitation on the exercise of provincial powers that does not apply to most provinces and is no longer appropriate. Repealing Section 24 of the Saskatchewan Act at the request of the province would be a good example of federal-provincial cooperation.
The Governor-General is being authorized to proclaim a constitutional amendment, and so it should go without saying that the wording of the constitutional amendment must be identical in each of the federal and provincial resolutions and in each official language version of the text. Madam Speaker, to come to the proposed amendment at hand, on November 29, 2021, the Legislative Assembly of Saskatchewan unanimously adopted a resolution to amend the Constitution of Canada to repeal, retroactive to August 1966, Section 24 of the Saskatchewan Act, the enactment that created the province of Saskatchewan. This section of the Act purports to subject Saskatchewan's constitutional powers to Clause 16 of an agreement dating back to 1880 between the Government of Canada and the founders of the Canadian Pacific Railway Company, or as it is now commonly referred to as a CPR. This clause exempted CPR from certain federal, provincial, and municipal taxes, and I quote, forever. Despite its tax exemption in 1966, CPR agreed to pay applicable taxes. More recently, CPR brought claims against all governments involved to reassert its historical tax exemption. The amendment proposed by the Legislative Assembly of Saskatchewan is similar to the 7 others that have already been made to the bilateral procedure since 1982. It aims to amending a provision of the Constitution that does not apply to all provinces. The amendment itself would only apply to one province. The amendment was initiated by the Legislative Assembly of the province before coming before us, and the amendment would effectively modernize certain aspects of the Constitution, and in this case, by removing a limit on the exercise of powers of the province that does not apply to most of the other provinces, and which is no longer appropriate. Moreover, repealing Section 24 of the Saskatchewan Act would be a nice example of federal-provincial cooperation. Saskatchewan's concern regarding Section 24 are threefold. First, Saskatchewan is of the view that it would be inconsistent with the province's position as an equal partner in Confederation if the provision restricted Saskatchewan's taxation powers relative to those of the other provinces in Canada. Second, Saskatchewan believes that it would be unfair for other businesses operating in the province, including small businesses, if a major corporation were exempt from certain provincial taxes, providing that corporation is a significant competitive advantage over those other businesses, to the detriment of farmers, consumers, and producers of the province. Thirdly, Saskatchewan asserts that it would be unfair to the residents of Saskatchewan if a major corporation were exempt from certain provincial taxes, casting an additional tax burden onto the people of Saskatchewan. Back in 1880, this exemption for a single large corporation may very well have been appropriate, as it was intended to recognize and encourage CPR's investment in the construction of the Trans-Canadian Rail Network in the late 19th century. As such, it was just one of the incentives that Canada offered CPR to build Canada's first cross-country railway in fulfillment of a promise made to British Columbia for joining Confederation. While there may have been valid reasons to grant CPR's founders a tax exemption as part of a series of measures to support the construction of Canada's transcontinental railway, those reasons no longer stand now that the construction is completed and Canada's transportation legislation has been modernized. In broader terms, Section 24 of Saskatchewan's founding statute and CPR's historic tax exemption have not kept pace with how Canada's tax and fiscal policies have evolved to support an effective and efficient transportation system and a healthy, growing economy. Under the division of powers in our Constitution, the provinces are granted a general power to impose direct taxes. Section 24 seeks to constrain Saskatchewan's ability to do so with respect to the CPR. Yet, not all provinces are subject to such a constraint, resulting in an asymmetry within the Federation. Our government believes that Saskatchewan would have the freedom to levy taxes within the province's boundaries as they deem appropriate. We agree with our Saskatchewan counterpart, that other taxpayers in the province should not bear a heavier tax burden as a result of a single large corporation benefiting from an exceptional exemption from provincial taxation. And we also agree that there should be a level playing field between all businesses operating in Saskatchewan's transportation industry. And as we all know, the completion of this railway was a fundamental to the birth of our nation and the subsequent rapid growth and development of our economy. The last spike uniting East and West is an iconic representation of our national heritage and unity. If proclaimed, constitutional amendment would have the effect of removing CPR's tax exemption from the Saskatchewan Act, retroactive to August 29, 1966, the date on which CPR entered into an agreement with the federal government to forego its perpetual exemption from some taxes. The Constitution was not amended to reflect this agreement at the time because it had not yet been patriated. Il importe que non seulement on vise le fond, mais également.
We must ensure that the procedure and the constitutional amendments are done properly and that the methods be faithfully respected. The Constitution, as the Supreme Court teaches us, is the expression of the Canadian population's sovereignty. And that the Canadian population, acting through governments, ensures that under the Constitution, has the power to implement constitutional powers on the Canadian territory.
That this is a very important constitutional amendment, one that is rooted in fairness and to ensure that all Canadian corporations, particularly in Saskatchewan, pay their fair share of taxes. And I look forward to ensuring the passage of this motion today, as well as questions and comments from our colleagues. Thank you, Madam Speaker.